Supreme Court will be in session to hear the case of the State versus William Long. So to tell you a little bit about this, this is not a mock hearing. This is a real case. These are real attorneys. There are attorneys assigned to these cases, and it will be heard by the full 7-judge panel of the Oregon Supreme Court. My name is Alta Brady. I'm the presiding judge for the Circuit Court of Deschutes County. Circuit Court is the trial level, and this is where a case begins. In Circuit Court, the outcome of the case is decided by a judge or by the jury. The first case you will hear this morning started out as a jury trial. The next level of review is the Oregon Court of Appeals. They are the first level of appellate review. The decision of the Court of Appeals either affirms or reverses the decision of the trial court, the Circuit Court. The next level of appeal is what you are about to see. The Oregon Supreme Court has the option of not taking a case on appeal. If the Supreme Court decides not to hear the case on appeal, the case will end with the decision of the Court of Appeals. Now, if the Supreme Court decides to hear the appeal, like it has today, then the decision will either affirm or reverse the decision of the Court of Appeals. Now, let me tell you in advance, you will hear arguments of the attorneys. There will likely be a good number of questions from the Supreme Court justices. Prior to this hearing starting, they have reviewed briefs, written documents that have been filed by both sides that list their arguments, that talks about the authorities that they're relying upon, and what result they think the Supreme Court should reach. So you may find that the Supreme Court seems to know an awful lot about the topic even before the case starts, and that's because they've already done their homework in advance, and they're ready now to ask specific questions of the attorneys so they can make their decision. In this case, this involves the admissibility of evidence in a criminal case. The defendant was stopped by the police and was detained in the back of a patrol car, was handcuffed, while the officer was verifying his identity. The defendant was asked if there was anything in his car that the officer would be concerned about, and the defendant said no and told the officer he could search the car if he wanted. And when the car was searched, there was a fanny pack that was found that had drug residue and paraphernalia in it. One of the questions involved in this case is whether or not the consent that was given by the defendant to search his car was invalid because the defendant was already in custody and had not been given his Miranda rights. Now, the court is about to begin, and this auditorium will be a giant Supreme Court courtroom. What that means is all of the courtroom rules do apply, and those include refraining from talking or chewing gum or eating or drinking. You can't take any photographs, and I'm also going to ask you this time to double check all of those electronic devices that everyone carries these days to make sure that they're off and they stay off during the course of the argument. Now, after this case is over, argument is over and the Chief Justice indicates the argument is concluded, they will give an opportunity for you to ask questions of them. So if you do have some questions, you'll need to come to one of the two microphones that are just at the base of the stage. They will not be able to comment on a particular case that they've heard, but they're certainly willing to answer other questions you may have. So I hope you enjoyed this rare opportunity to watch the judicial branch in progress. Thank you.
Good morning.
Good morning.
Welcome back if you were here earlier. Welcome if you just came in. Thank you, Judge Brady, for your instructions. One couple of things I need to remind you about in addition to the cell phones, which we had no problem with last time, that was wonderful. If you do get up and leave the auditorium, which I strongly discourage you doing, you cannot come back in. So once you go out, you're out. So if you need to use the restroom, sorry, you're out of luck. The question and answer period is a really important part of this process. It's one of the reasons why the court comes to the schools. Is not only do we want you to see what the court does and how it operates, but it's an opportunity for you to ask questions of the court and enter into a dialogue with them. You can ask them anything about how the process works, how they became judges, what they do, how they make their decisions. They're open to all of that. As Judge Brady said, they will not talk about the case that you are about to hear or the first case of the morning. Other than that, it's all pretty much free game. Let's see, anything else? Hats, no gum, no cell phones. If you go out, you can't come in. think that's all. Oh, so I'm going to bang the gavel in a couple of minutes, and I'll ask you to rise. Please remain standing until the Chief Justice asks you to be seated, and we'll get started. Thank you.
Thank you. Please be seated. Welcome. We're glad to have a lot of students and other elected officials here today, and judges. So thank you. We're here to hear argument in the case of State v. DeLong, and we will hear the argument, then we'll have 15 minutes or so for questions. So we will begin with Mr. Casper.
Thank you, and may it please the court and counsel, I am Michael Casper on behalf of the state of Oregon. This case is about a Miranda violation. Violation consisted of a single question. Is there anything in your car I should be concerned about? The question
Can I ask you a question about the question?
Yes.
When defendant quotes the question on page 8 of his brief, he says, I asked Mr. DeLong if there was anything we should be concerned about. There's no reference to car in the quote the defendant puts out. And it might make a difference. I know you quote it sometimes as the vehicle, but you appear to take it from the Court of Appeals opinion, and I wasn't sure if the record had multiple ways that the question was asked, or if there was a misprint in the defendant's brief, or what.
Well, there was the description in the record about what precisely occurred in terms of what exactly was said. The police officer was trying to describe roughly what he said, and the defendant was trying to remember what he thought the officer said. So there may be different things on different transcript pages, but I think that...
I assume you take it the light most favorable to the trial court's ruling, which would be consistently the trial court's ruling, just for the state.
Right. And I guess to be frank with you, I'm not sure, you're saying it could make a difference.
Yeah,
and I'm not sure what the difference is, and so I don't know which way to look at it.
Let me pose the difference briefly. The question, preceding discussion, I apologize for taking over your statement of the facts. Preceding discussion had been about identity, where this person was from, who he was, blah, blah, blah.
Right.
If the next question is there anything we should be concerned about with no reference to the car, defendant's response, no, you want to search my car, appears not to follow as closely from a question that has no reference to car in it. Whereas if they said, if there's anything in your car we should be concerned about, perhaps it's more understandable the defendant would say, no, you want to search the car. And so, just a small point, but I couldn't tell what was going on.
Right. And I think that the state, from my best reading of the record, is that what the question was, is there anything in your car that we should be concerned about? And because what the officer said is, I asked him whether there was anything in your car that we should be concerned about, and he responded, no, you can check it if you want. So I mean, it was clear that the question was about the car, and the response, both in terms of the immediate answer, no, you don't need to be concerned about anything, and hey, inviting him to search it, were both in response to the question. Does that make sense? So I don't think it was a general question of, is there anything we need to be concerned about here?
And your position is that's the only question that was asked in violation of the Miranda rule?
Yes.
Because I thought I understood the defendant to argue that all of the questions about identity and the other questions potentially are Miranda violations as well.
And the state's position is that those are not Miranda violations, and nobody has argued at any level up until now that those were Miranda violations. The only question in the trial court was whether or not the statement, is there anything here we should be concerned about here, or anything in the car that we should be concerned about, was a Miranda violation. So I think that is the single Miranda violation that this court needs to consider.
And am I correct that the trial court originally found that wasn't even a Miranda violation?
You are correct. The trial court's ruling was that Miranda warnings were not needed at that point.
and the state, beginning with the Court of Appeals, has agreed that Miranda warnings were called for before asking that.
That's correct. When a suspect is in lawful custody, if an officer asks a question that is reasonably likely to elicit an incriminating response, then that is interrogation, and that requires Miranda warnings beforehand. And the state's position in the Court of Appeals was the question, is there anything in your car that we should be concerned about? Is reasonably likely to elicit an incriminating response, and therefore it did require a Miranda warning. However, it didn't elicit an incriminating response. The only thing, and this is getting back to my quick statement of facts I promise, but the only thing it had elicited was, it elicited no information that was incriminating, and there was nothing about the way the question was asked, the substance of the question, or the information that it elicited that changed defendant's position with respect to being able to prevent the officer from searching his car. And there's nothing about the way the question was asked or the information that it elicited that changed the officer's position in the sense that it gave him an advantage to searching the car.
But this was a stop because of a seatbelt violation, is that right?
That's correct. It was originally a stop for a seatbelt violation. He wasn't wearing a seatbelt, so it was a lawful stop for a seatbelt violation. He asked for his driver's license, and the defendant did not have a driver's license for picture identification.
And so when did the handcuffs in the patrol car happen?
After the defendant was not able to provide identification of any kind, so that there is a statute, ORS, I think it's 807, 570,
Misdemeanor?
yeah, failure to carry and present a license. So he was lawfully holding him while he was trying to determine what his identification was, and the testimony was, as soon as I was able to figure that out, I would have let him on his way with the citation, perhaps for the seatbelt violation, or perhaps.
But this was a pretext stop, though, wasn't it?
It was not a pretext stop, although I think there was. The officer was suspicious about the defendant's behavior. So he's driving. He notices that the defendant noticed him driving behind him, and what the officer perceived is that the defendant immediately pulled off into a parking lot. And as soon as the officer went past, he looked in his rearview mirror and saw that the defendant re-entering. He thought that was suspicious, so then he looked in the car and saw that he wasn't wearing a seatbelt. There's no evidence in the record to say that I used that as a pretext to stop him because I was suspicious, but it maybe explained why he looked in the car and saw that he wasn't wearing a seatbelt.
So, Mr. Casper, the issue, as I understand it in this case, is whether the evidence that was found in the search of the car derived within the meaning of Article 1, Section 12, as this court has explained it in Montana, from a Miranda violation.
Correct.
And so, I'm interested in an argument that you're making, and I'm not quite sure why you're making it, so I'd like some help, that you're asking for what I think you describe as a softened version of the Von Den test for derivation, in which you would ask, did the violation allow the police to directly obtain the evidence or otherwise deprive the defendant of the ability to prevent obtaining it?
Right.
Do you need that softened standard to win?
No, in fact, that's my introduction here. The next thing I was going to say is there are two analytical paths that the court could take in this case. One of them is the one that is suggested by Von Den, and I think I have to say that I don't think the analysis in Von Den is perfectly clear. We know that there's a derived test, but we don't exactly know what derived means. But so one of the paths to take is the path taken in Von Den, which is to start from the premise that a Miranda violation is a constitutional violation. That a Miranda violation is a violation of Article 1, Section 12, which prohibits the state from compelled use of testimony. And then from there to say, well, we need to vindicate that violation, and we look to see whether the violation was exploited by the police and that the evidence is the result of exploitation. So that is one path the court could take, and I do believe you're correct that, I don't know if you're, that this may be implicit in your question, even under that framework, the state wins in this case because there's, as I laid out the facts, there's nothing about the question that was asked in this case or the answer that it elicited that gave the state, the officer, any advantage in obtaining consent. And if you look at the court's recent description of an exploitation analysis in the search and seizure context, in Unger, what the court says is exploitation analysis recognizes that unconstitutional police conduct may fall short of coercion consent, but requires suppression because police took advantage of information gained from their conduct to obtain consent. And so that would be under an exploitation analysis. The operative question, is there anything about the Miranda violation here that allowed the officer to sort of leverage his way into consent? And the answer to that is no. But the problem, and so if the court chooses to go that path, I think the state will prevail in this case. But I guess the concern that I have, and the reason I did ask for a softened version of the Von Dane test, is that the second analytical path is not to assume that a Miranda violation is a constitutional violation. Because a Miranda violation is not a constitutional violation. The Oregon Constitution says that no person shall be compelled in any criminal prosecution to testify against himself. It requires, if nothing else, compulsion. A Miranda violation in and of itself, asking a question, does not necessarily compel anything. There is a risk that it compels an answer. There is a risk that because of the inherently compelling nature of custodial interrogation, that the answer that the individual gives is not knowing and voluntary, doesn't know his Article 1, Section 12 rights, and didn't voluntarily waive them. There's a risk of that, but it's not a certainty. So we do not know at the point of a Miranda violation whether a constitutional violation has occurred. And moreover, no evidence has been presented against that person at the time of the Miranda violation. So analytically speaking, there's no way you can find in the text, the context, or the history of Article 1, Section 12, anything that says police officers are required to make people aware of their Article 1, Section 12 rights at the time of custodial interrogation.
So in your view, what flows from that distinction? In other words, why does it matter?
Why it matters is because under the second analytical path, we're not looking at exploitation. We're looking purely at whether the consent was voluntary. Because Article 1, Section 12 requires compulsion. And so if there's voluntary consent, there's no risk of compelled evidence being admitted. And so that is a complete and dispositive question. If the consent was voluntary, then there's no Article 1, Section 12 violation. Now,
isn't there, I mean, and this is where I sort of get a little bit mixed up because things get ambiguous for me, but even in the federal world, if you look at cyber, one way of reading cyber is they say, yes, it's not a constitutionally, Miranda rights are judge-made rules designed to effectuate a constitutional right. They're not constitutionally mandated themselves, but they appear to employ sort of, I would say, an exploitation test. They call it, were the Miranda rights effective? But in asking whether they were effective, they're basically asking whether or not there's a sufficient separation between the previous violation and what comes out.
okay, and I disagree pointedly with that analysis of the cyber case. And in fact, I think what you see in cyber is the court actually explicitly, and in that case explicitly, saying this is not a fruit of the poison industry. This is not a constitutional violation.
I know they say that, but I wonder whether they're saying one thing and doing another.
Right, and I don't think they're doing another. I think what they're saying is, when they say, was the subsequent Miranda violation effective, they're saying, they're looking at whether it was voluntary. They're looking at the question of whether or not the consent that followed, or the statements that followed, were compelled or were not compelled.
So in the cyber, if there was a voluntary decision to waive, but yet it was the fruit of the prior confession that was extracted from the defendant without Miranda, you say that it would be admissible?
It would be admissible. The operative question, as you noted, is whether or not the subsequent Miranda warning was effective. And I mean, what it means for a Miranda warning to be effective is not perfectly clear, but I would say what it means is, or what it ought to mean, if we're being sort of intellectually coherent in our analysis, what it ought to mean is that the resulting statements were not compelled, because
They were also knowing, because in the second instance, that the officer gives the Miranda warning, so that information, the answers are not only voluntary, they're knowing at that point.
No, I agree with that, but I think the point was, it's not an exploitation analysis that's going on. If it was an exploitation analysis, you would simply say, as in LSTAT, you would say, well, there's an intervening circumstance. There is a warning, that ought to be enough. It's not always enough. We look and see whether it was effective. Did it work? And that's why it isn't an exploitation test.
So is your alternative argument a refinement or a modification of the Von Den test, or is it inconsistent with it, or a repudiation?
It is a clarification, it's a modification of the Von Dane test. And all we would be asked is that the court revisit the notion that a Miranda violation is itself a constitutional violation.
Because Von Den did say that much, isn't it?
It said it, and so we are asking you to overturn that. And it's not dictum either. I can't sit here and tell you that didn't play any role in the ultimate conclusion, but it's not necessary to the ultimate conclusion. If you look at the facts in Von Dane, so if Von Dane was a case that is similar in many ways to this one. It was an officer is with somebody who has a backpack, and he wants to know if the backpack contains drugs. He asked 3 questions. Is this your backpack? Yes, it is. Are there drugs inside? Yes, there are, and that's key. He lets the cat out of the bag. Yes, there are drugs in that backpack. And the 3rd question, can I search it? At that point, he says, yeah. And I don't think that the result that this court reached in Von Dane is necessarily wrong, that ought to have been suppressed, but not because the officer exploited a constitutional violation. In fact, if you look at those facts, it's hard to find exploitation. What you're seeing is something about the earlier questions and responses changed the calculus for this person in a way that it was no longer, looking at least at the scenario as a whole, you can't say he voluntarily gave up what was in his backpack. He gave up what was in his backpack because of some statements that were made in response to unwarned questions, which are presumptively compelled. And so I think what ought to have been the analysis in Von Dane ought to have been, let's look at what's voluntary and what's involuntary. And in order to, I don't want to create an incentive for officers not to give Miranda warnings. So, I mean, I think you can have a rigorous test about what is voluntary and what is not voluntary, and you can look at how the failure to give a Miranda warning and ask potentially incriminating questions, that plays into the question of that takes a compelling scenario and makes it even more compelling.
So in that regard, let's just take the facts of this case. And I do understand the state's position that what happened was a non-responsive answer was given by the defendant to a general inquiry about something I should be concerned about. And that because it was sort of non-responsive, unexpected, and not really what the officer was aiming at, it was voluntary. I'm simplifying, but don't we know, and maybe we don't, but it's more of a question than a statement, that officers ask questions like this all the time, hoping for just this kind of answer. And that it's a little arguably disingenuous to say this is non-responsive, when in fact it's exactly what was hoped for, if not expected. Now that sounds more argumentative than I mean it, but you get my point.
I get your point. Let's start from this point, which is undisputed here. Defendant and I agree on this. If the officer, as in this case, had said, forget the first question, but instead it said, can I search your car? That is not, Miranda warnings are not required. and if it's voluntary, the answer, if it's a voluntary yes, then the search is lawful. If the officer had said, in this case, can I search your car for anything that I'm worried about? There's nothing wrong with that. There's nothing wrong with that, and it doesn't require Miranda warnings. Why on earth would we come up with a rule of law that says, in this scenario, where the officer asked, is there anything in your car that I'm worried about? And the defendant said no, and then volunteered and invited the officer to search. So, therefore, indicating that not only that it was freely made, but that the defendant knew that he had to give the officer permission. He wasn't even asked for permission. And why on earth would we say that ought to be suppressed when in the former it shouldn't? There's no good principled reason that would protect Article 1, Section 12 for distinguishing those two factors.
Suppose the first question the officer asked was phrased slightly differently. Shouldn't give Miranda warnings, guys in handcuffs. And he says, you don't have anything in your car, you don't have any drugs in your car, do you? And the defendant says, no. And then the officer says, well, you won't mind if I search, will you? And the defendant says, well, I guess not. Do you think that second question in consent is not the product of the first question and answer?
It might well be. I mean, but I think that if this court, I think that trial courts would need some direction from this court about some of the factors that they need to look at in the context of a failure to give Miranda warnings that indicate where this court does not think that the subsequent granting of consent is involuntary.
I don't see why we don't have that. It's not focused on solely on voluntariness, but didn't we do that in Jarnigan? Didn't we say that the test was the response sufficiently a product of the earlier violation that suppression is necessary to vindicate the right? And then didn't we list a number of factors to help us determine that?
Yes, and
Why don't we just apply Jarnigan here then?
because Jarnigan repeats the same mistake that Van Dane made, which is to start from the premise that there was a constitutional violation and asks, how do we vindicate? And it's important, I think, for this court to get its Article 1, Section 12 case law.
Well, let's say that they said we start from the premise that there's a Miranda violation. And what do we do to determine whether the response is a product of the Miranda violation?
That, I think, is fine.
Okay, then why don't we apply those factors in Jarnigan for that purpose?
If the purpose in applying the Jarnigan factors, and when I looked at sort of developing a question of how should courts determine whether consent was truly voluntary, I looked at the Jarnigan factors. I mean, I
The
think
question isn't whether it's truly voluntary. The question is whether the response is a product of the failure to tell the person with a right to remain silent that the person has the right, so that the waiver is knowing and voluntary. That wasn't done by stipulation here. Now the question is the response a product of that failure to warn?
Respectfully, the question I think that the court should be asking is whether the consent was valid in light of the Miranda warning. And in order to find out if the lack of Miranda warnings, and in order to find out if the consent was valid, then it would, voluntary is the word I'm trying to say. If the consent was voluntary, then there's no compulsion, and we don't need to be concerned about protecting compelled evidence from coming in. So at that point, there's been no constitutional violation, and there's been a voluntary granting of consent. There's no Article 1, Section 12 problem.
Well then, why in Van Dane, taking aside the question of whether there's a constitutional violation, do we ask whether the consent, which was the third step in the process, we don't ask whether that was voluntary, we ask whether that's a product of the failure to warn.
Right, and I guess what I'm saying is, if you ask if it's a product, that's sort of loaded language, which suggests an exploitation analysis.
Or it suggests an analysis, a causal connection analysis.
Okay, well, that could be that could be a third route, which is to say all there has to be is a causal connection. And the state doesn't dispute that there is a causal connection.
A sufficient causal connection is what we looked at in Jarnigan. we looked at a lot of factors to see, this happened the next day. Were the two closely enough connected, given these factors, that we can say there's a product of the violation?
But the violation itself is not in violation of the Constitution, and so what we're concerned about ultimately is the purpose of the Miranda rule. The purpose of the Miranda rule is to prevent any compelled testimony from, or compelled evidence from being presented against the defendant. That purpose is fully served if the consent was voluntary. And so I agree that we look at the relationship between the Miranda violation and the ensuing consent. And we want to look carefully at the nature of that relationship and how one affected the other. But the relevant, for purposes of Article 1, Section 12, the relevant consideration in looking at what the effect was is, well, at the end of the day, was the consent voluntary? Because if it was, notwithstanding the connection between the Miranda violation and the decision to consent, if it was voluntary, then there's no compulsion and there's no problem under Article 1, Section 12, and the purpose of Miranda is fully served.
Is this like is your argument kind of a backdoor way of working Patain in?
No. and I mean, I was cognizant of that, and it is a backdoor way. It is a way of softening. It is a way of softening what I think was wrong about Von Dang. But what Patain does, and I see my red light outside. Does that mean I'm
Finish the sentence, yeah.
Okay.
This answer.
What Patain does is it says, if we're talking about physical evidence, then physical evidence that derives from a Miranda violation, we're going to look back and see whether, forget the Miranda presumption that is compelled, we're going to actually look and see whether it was compelled. The state's test here does not ask the court to look past the Miranda presumption. Any statements that were made in violation of Miranda, this court can and should continue to presume are compelled. But the ultimate question when you're talking about a consent that follows from compelled statements is, even assuming those were compelled, is the consent compelled? Because if the consent is not compelled and the statements that were compelled aren't coming in, but the product of the consent is, there's no problem if the consent is voluntary.
Yeah, but Mr. Casper, we've sort of avoided talking about the relationship between Article 1, Section 12 and Article 1, Section 9, and this case and the Unger-related cases, because they are different. You might want to think about why, because we rejected the state's argument in
Right.
Unger, although you ultimately won that case, we rejected your argument that voluntary consent always trumps.
Right, and I want to make clear that I'm not saying.
No, I understand.
I understand.
You can tell us about it on rebuttal, and come up with a really succinct and correct answer on rebuttal. So, Mr. Bennett.
Good morning. May it please the court and counsel, Daniel Bennett on behalf of Defendant William DeLong. And I'd like to begin this morning with a note of quick clarification on the record issue that was addressed at the beginning of counsel's argument. The page that I cited in my brief is page 8, which indeed does contain what Justice Kistler asked. It's, I think, clarified somewhat a little bit later on page 20 in the transcript of the pretrial hearing, where there's a discussion about how the consent to search came about. The defense counsel asks, is your testimony that he volunteered? Yes. After you say, is there anything in the car? Yes. So I think read in tandem, those suggest that the question, at least as understood by the parties, was whether there was anything you should be concerned about in the car, and I think that's how both parties have treated it throughout. With that clarification of the record, I'd also like to address and perhaps clarify the finding that the trial court made, which the state relies greatly upon, and that's the finding of this voluntariness of defendant's consent. Now, the trial court only reached that issue of defendant's consent when it addressed the defendant's secondary argument, which is not raised on appeal, that there was sort of a Article 1, Section 9 violation and no valid voluntary consent. The trial court did not consider the validity and the voluntariness of the consent in light of the Article 1, Section 12 violation, because the court found that there was no Article 1, Section 12 violation. So to the extent it said that the defendant's statement was voluntary, and in fact what it said was it was volunteered, its understanding was it was not a direct response to the question, That was not considering it through the framework of Miranda, where we examined whether the unwarned questioning could lead to a presumed compelled response. So the trial court said this was voluntary, but it didn't have to address what effect unlawful, unwarned interrogation would have upon that consent, because it didn't believe that such interrogation had occurred. The issue in this case is fundamentally whether or not Von Den stands and allows for the suppression of physical evidence that's derived from a Miranda violation and derived from unwarned questioning. Defendant was arrested, the state acknowledges this. Defendant was interrogated, and the state acknowledges this. And
What was the Miranda violation? At what point did that violation occur?
well, I'm going to answer that by saying we would wish for slightly more clarity in some of the questions that were asked. What I will point to specifically is the question we've been relying upon, is there anything in the car that I should be concerned about?
And was that defendant's position at trial, was it focused on that question?
Yes, I believe so.
So to the degree you've argued that now that the violation occurred earlier, that would not be preserved.
It was not my intention, Your Honor, to argue that there was an earlier Miranda violation, and I apologize if I gave that impression. What defendant's position is that although the question that required warnings beforehand was the specific one that we've discussed throughout, that was not the beginning of the atmosphere in which defendant was being questioned and investigated by the police officer. Now, we agree that the case law is clear that an officer may ask preliminary booking questions and those sorts of questions, such as seeking his identity, without providing Miranda warnings.
The state also suggests that an officer can ask for consent to search without giving prior Miranda warnings. Is that correct?
That is correct. That is the case law. Yeah, I would frankly love to challenge that, but that's not before this court.
Accepting that then, for the sake of the question, what is the real difference between saying, can I search your car for anything I should be concerned about, and do you have anything in the car I should be concerned about?
This court has held that when an officer asks a person for consent to search a vehicle, the response that will be derived from that questioning is not incriminating evidence. That is to say, the operative fact, yes, you may search, or no, you may not search, is not in and of itself an incriminating response. Whereas something more broad that even if it is essentially asking that same question, but is also inviting the defendant to elaborate, can in fact lead to that incriminating information. Now, I'm not sure I'm entirely comfortable with the distinction that the court has drawn where asking for consent to search is not incriminating, but I think the fact is that if a defendant there said, no, you may not, that couldn't be introduced against them.
Do we have cases that deal with that issue in the context of custodial interrogation? In a funny sort of way, I wonder if it's not mixing apples and oranges, because ordinarily in a custodial interrogation, you're looking at searches incident to arrest and that sort of thing. So I'm wondering if any of our cases that talk about an officer's ability to ask for consent without a Miranda violation or Miranda warning involve custodial interrogations. I presume they do, but I just don't know offhand. Do you?
Well, Von Den, and it may only be in the current of Von Den. Von Den at least states that explicitly, and I believe there are, but I can't recall off the top at the moment. I'm pretty sure that there are, but I think the difference is asking, directly, may I search, versus, is there anything that I should be concerned about? The latter invites the defendant to give a variety of responses. He could simply say no, he could say yes, he could say, you got me, there's an unlicensed firearm, or he could, as he did in this case, say no, and you may search it. That answer is derived from that questioning, the direct response to that questioning. In fact, in Unger, this court gave almost that exact scenario as an example of a direct derivation. Said, I believe it referred back to Kennedy or Rodriguez and said, as a factual matter, the response that the defendant gave in those situations was derived from what was caused by that questioning. However, the question before this court is whether the defendant is not, I should say, asking for this court to apply simply the but-for causation. This court, in Von Den and concurrence expressed some concern about how exactly courts are to apply the derived from frankly that London and Jarnigan resolve this case, but to the extent that there's a need to clarify, examine, or go into any more depth on how you determine that something is derived by, I think it could be from the nature of the question.
Well, let me ask you about that, because I'm not sure Jarnigan Clare resolves the case, at least for me. Here, there's a different kind of calculus. That is, they ask, defendant exercises free will at some point. Assume if they said, no, the defendant says, no, there's nothing in the car, the officer says, may I search? The defendant says, yes. That's a choice defendant makes that may attenuate any harm flowing from the impermissible question. You got things like the harming in the car. Here, it's even further attenuated, and the defendant says, no, you want to search my car. Why isn't that sort of volunteered response sufficient to suggest that the defendant's statement is not the product of the officer's violation?
Yeah, and I'd say the answer to that question, Your Honor, is we don't, and we haven't traditionally gone into the sort of analysis that would really provide the answer I think that the state is looking for, which is how do we know that the words that came out of the defendant's mouth were coerced? There's a reason that we don't go into that argument, that sort of analysis, which is under the framework of Miranda, we don't have to. The Supreme Court in Miranda said making a determination of what's going through a person's mind when they decide to respond to interrogation is very, very difficult. There's a lot of factors that go into it, and it's hard to unwind that decision. So hard, in fact, that we're going to create this rule whereby trial courts aren't daily struggling with sort of psychoanalyzing the various actors and determining how this questioning, this unlawful questioning, would have affected someone's decision.
And again, I'm operating off memory, so my memory is always going to be imperfect. But my memory was the court was trying to avoid the difficulty in figuring out what was compelled and what wasn't. Does it hold, and have we held that everything that follows an unwarned Miranda violation is going to be suppressible?
Everything that directly follows from it is presumptively compelled, particularly with statements.
Even if the defendant volunteers something?
Didn't Miranda itself say that any kind of volunteering statement would not be subject to exclusion?
Well, that gets into the question of what is voluntary to override the presumption of compulsion in Miranda, and I would admit that that's not an easy question to answer. I don't think it's sufficient to say that the defendant was not physically forced or emotionally forced to make this statement, therefore we can say for all purposes it's volunteered, it's voluntary, such that we ignore the preceding illegality. The amicus in this case sort of gave some information on what might go into a person's decision to respond to police authority. This defendant's position that, that's useful information, but applying that test case by case, factor by factor, each time we deal with this sort of unwarned questioning is going to be difficult, if not impossible, for trial courts. And that's why we have the benefit of, a broad rule that says you need to give these warnings and things that come from these warnings. And I should clarify, even if they are volunteered, they're not knowing. The waiver of defendant's rights that have been violated here is not and cannot be knowing. And that's the primary distinction between Article 1, Section 12 and the Article 1, Section 9 cases.
So even if the defendant says, you didn't ask me about my dope in the car, but I'd like to volunteer a few things, tell you something, because that's not knowing, that's inadmissible?
Well, I would say that depends upon the question that preceded that. I mean, you said you didn't ask me about the dope, but I'd like to volunteer. And I'd say we go back then and look at what was the question that elicited that response. And if there was, in fact, no question, even arguably on that point, the defendant's response was a true non sequitur, a true blurting out or completely volunteered statement, then no, that is not derived from unlawful, unwarranted interrogation. And yes, that would be admissible. If, in fact, the officer is asking...
Actually, there would be no but-for causation in that circumstance, right?
There would not be if there was no questioning whatsoever. Or if there was, another counterexample I would give is if the officer was asking very specific questions about, your car. Do you have anything in your glove box? Do you have anything in your trunk? Do you have, do you have drugs? Do you have guns? And the defendant says, well, I'm going to tell you that actually I committed a murder and there's a murder weapon buried in my backyard. Now that is but-for caused by the officer's questioning. Presumably the defendant would have remained silent if he wasn't engaged in the conversation. But I think that's a situation where the sort of factors that this court outlined in Jarnigan could provide a useful guidepost for determining whether or not this was actually caused by that unlawful questioning, or if it's so attenuated and there's so much in the middle that perhaps, nevertheless, the evidence is admissible.
Is that a voluntariness analysis or a causal relationship analysis?
I would say the latter. Well, a little of both. You know, the question of whether something is presumptively coerced by unlawful questioning gets into whether the unlawful questioning is unlikely or is likely to elicit that particular response. We say that a defendant is being interrogated when they're asked a question that is likely to lead to incriminating information. So if the question that's being asked is not one that is actually likely to lead to incriminating information, the defendant is not being unlawfully interrogated, and we don't have a Miranda presumption against voluntariness of any response that he gives.
But it could be likely to lead to incriminating information, but it leads to something else. And so I'm asking you in that instance where you ask, is there anything in your glove box? And the defendant says, there's a body in my backyard. Why is that body in the backyard admissible? Is it because it wasn't caused by the violation, or because it's voluntary, or?
Well, I should be honest. I certainly would not concede that in that case the body in the backyard would be admissible. I think that if we had that case, the defendant would be arguing that it was caused by that questioning. But candidly, in this context, I think there's a little bit more of at least an argument to be made that no officer would or should understand that his question is going to elicit that type of evidence. I would be fine. I think the defendant would be fine with a rule whereby there is simply a direct causation test. If the questioning leads to the discovery of the physical evidence, it should be suppressed. That would be our
Well,
position.
that's a but-for test, though, and you said you don't want a but-for test.
I would love a but-for test, but I see
Well,
myself as
you're not arguing that here.
correct. That's absolutely correct, Your Honor.
So it has to be something more than but-for, and how much more, that's what we're supposed to figure out. Derived from the product of, does it become just like the exploitation analysis under Article 1, Section 9?
I don't think it does precisely, no, Your Honor. I think it's really a question of, we have a direct causation, we have a but-for causation. If the court, is not inclined to adopt simply a rule that a but-for causation applies, then there needs to be something else, something sort of resembling approximate cause analysis.
Right.
And that's why I think, the court can look to the concept of what constitutes the violation. What constitutes the violation is unlawful interrogation. Unlawful interrogation is questioning likely to elicit incriminating evidence. So it perhaps makes sense to see, well, if we're going to look for some other, legal cause rather than just a factual cause for determining if the evidence is derived from, well, we look to see whether this is in fact.
But wouldn't the factors be the same as we talked about in Unger, and could include, and I think we say a little bit about this in Jarnigan, things like flagrancy and the egregiousness of the police conduct, proximity in time. Is it a totality of the circumstances test to determine whether one is derived from the other?
Well, I guess I would have to say I would have to give a little more thought to which of those factors would go to vindicating the issue here. In the Unger scenario, you have a person who has been subject to some sort of illegality, but has nevertheless given consent, and the question is that consent voluntary, or did some action on the part of the police,
No, we know the consent's voluntary. The question, that everybody agrees the consent's voluntary. The question is whether it is the result of exploitation of the prior illegal police conduct.
Yeah, and I'd say here the answer is much simpler. We don't know that the consent is in fact voluntary. I mean, we know that it wasn't beaten out of the defendant, but it was in response to a question that should have been preceded by a Miranda warning. So in the sense that, defendant, that this court has said that responses to unlawful unwarranted interrogation are presumptively coerced, then this was not in fact voluntary. And I don't think the trial court's finding gets the state to the point where it was voluntary based on the nature of the argument before the court has ruled.
You aren't arguing this was involuntary in a constitutional sense, are you?
I'm arguing that it's coerced, presumptively coerced in the constitutional sense. And I think the use of voluntariness in this context can get a little bit confusing. It was not forced out of the defendant, I mean to say. It was not, physically or he was not emotionally overborne, or there's no evidence that he was. but we have the presumption that it was coerced, which I think is at least in tension with, saying that it was purely voluntary. So yes, I'm not saying in the involuntary sense that we use that word sometimes, that it was involuntary. But I'm nevertheless, as a lawyer, uncomfortable saying it was voluntary, which I realize now is
So
a politics.
you've indicated, Mr. Bennett, that you're satisfied with the formulation of the derivation test that the court gave in Montana. But from your brief, it looks to me like you're also proposing some gloss to that, or some additional substance or content to it. And I think I heard you, I wrote this down, tell me if I'm wrong, say that it needs to be something like proximate cause in order to be derived, evidence in order to be derived from the Miranda violation. And where the unwarranted questioning is likely to lead to incriminating evidence. Is that really the test you're advocating? Because in your brief, I thought you were using a foreseeability test, which is, as I understand it, somewhat different from likely to lead to incriminating evidence. I want to make sure, in other words, that I know exactly what you think the Von Den standard requires for derivation, and whether your proposed test is consistent with that in your mind, or embellishment of it, or what?
Yes, well, I will say first that foreseeability is the test that I propose in the brief, and if I said likely to lead to, that was a misstatement. Rather that it foreseeably could lead to it. So
It is a different standard.
it is a different standard, and I misspoke if I said likely, and I apologize for the confusion.
Why isn't the standard already the standard in Jarnigan? Why are we making a new standard, or am I missing? I thought Jarnigan said the question is it sufficiently the product of the violation that suppression is necessary to vindicate the violation, and that there are many factors, we look at the totality of the circumstances.
Yes, Your Honor, and I would candidly say that defendant believes that this court, as it explained it, the question in both Jarnigan and Von Den sufficiently answers it. And perhaps I should have been more clear in saying that, nevertheless, if the court feels there is a need to add a gloss or examine that test in another light, this is an alternative that it could explore. I do believe that the Jarnigan test set out, although Jarnigan is primarily dealing with subsequent testimonial statements rather than physical evidence, but I believe that is sufficient and workable for this situation. Absolutely. I'd like to briefly touch on the state's argument about voluntariness, and I'll be honest, I'm a little confused or unclear what's left of Von Den and how far apart we really would be from, or how far we would be from contained under the state's proposed test. The state makes much of saying that, the fact that the defendant voluntarily consented, although we again challenge that interpretation, but that really trumps an earlier violation. But that doesn't leave us with much if that's the standard the court adopted, because an involuntary consent is never going to be sufficient. That's never going to be sufficient under at least Article 1, Section 9, where an involuntary consent will never allow a warrantless search. The question is whether a Miranda violation can, whether a statement that is derived in direct response to unwarranted interrogation, violating the Miranda rule, can in fact overcome the need for some exception to the warrant requirement. The defendant's position is that it cannot. This was interrogation. The state doesn't challenge that this was interrogation. It's true, as the state says in its brief and as the court asked, if the officer had said, may we search the car under this court's case law, that would not be interrogation. By the same token, it's true that if the officer had given the Miranda warnings, that would not be unlawful interrogation. There were ways that this problem could have been avoided, but the officer engaged in unlawful unwarranted interrogation. Given that, and given the direct result that the defendant's consent came from that questioning, this court should affirm the decision of the Court of Appeals. Unless the court has any questions.
Thank you, Mr. Bennett.
Thank you.
Rebuttal, Mr. Casper.
Thank you. 3 points I want to make. The first one, Chief Justice Palmer, goes back to your question about isn't this just a redux of the same argument that the state gave us over and over again in the Article 1, Section 9 context? And in Article 1, Section 9, the state, beginning in Hall, argued, look, if you've got a voluntary consent following an illegal, unconstitutional seizure, voluntariness ought to be enough. You don't need to do any extra exploitation analysis. We lost that in Hall. We argued it again in Hemingway. We lost it in Hemingway. But we argued it again in Unger. We lost it again in Unger, and I promise we will never argue it again. But I really want, this is important to me because I am concerned that this court sees me doing exactly the same thing here. It is not the same thing.
No, I don't see you doing the same thing here, but I want to hear the articulation of the difference between the Article 1, Section 9 analysis and the Article 1, Section 12 analysis.
Right.
And also, remember, you won at the end of the day in Unger. Right. We didn't buy the defendant's per se argument either.
Right. We won at the end of the day in Unger, and one of the reasons that I think that we win under either of the two paths that I've articulated here, whether you do an exploitation test or whether you do a voluntariness test, I think we're going to win in either direction. Partly because of Unger. Unger gives me some confidence that the right question is whether or not the officers under an exploitation test, the officers took advantage from information they learned. But so I mean, you might ask, well, why is the state going out of its way to try to, if they're going to win anyway, if they think they're going to win anyway, to try to get us to go back and adjust this test? And I really do think that our concern at the end of the day is that the underlying assumption that a Miranda violation is itself a constitutional violation it's not consistent with the text or context of the constitutional provision.
But to get there, at least, we would have to overrule at least that part of Von Dane. Did we say exactly that in Von Dane?
You said exactly that in Von Dane, and you should overrule that part of Von Dane.
Okay, that's fair.
Yeah, I mean, even Von Dane itself is a decision that's is in some sense at war with itself, because there are two parts to the majority opinion. The first has to do with the physical evidence and whether that's admissible. And the analysis there says, well, Miranda violation is a constitutional violation, and that was derived from the evidence was derived, and therefore it should be suppressed. That's an exploitation analysis. The second issue in Von Dane was whether or not certain statements that were made after a Miranda warning was given, but given prior to the Miranda warning there was a violation, whether those should be admitted. And in that case, the court adopted the Seibert test, which is, Seibert has expressly said, we don't do exploitation because there's no constitutional violation. So it's got two parts of the same opinion that are going in two different directions. And so, I mean, even to make it consistent within itself, I think it's really important for this court to say, Miranda violations are not constitutional violations. What we need to do when there's a Miranda violation, if it's physical evidence, is to ask, do we need to suppress it in order to serve the purposes of the Miranda rule? And the purpose of the Miranda rule is to ensure that Article 1, Section 12 is not violated. And Article 1, Section 12 will not be violated if no compelled evidence is introduced.
So where I'm having difficulty is you say that statements made after a Miranda violation are presumed to be compelled, but that the consent might not be compelled, and what do you apply to get there? And that's what, it's just confusing to me, because your idea of compulsion can't
Right.
be just that you weren't threatened with a gun.
Right, well,
And so you've got this compelling circumstance, you have no knowing involuntary waiver, and so what is the test of whether it's risen to some other level that makes it admissible?
Not every statement that follows from a Miranda violation is suppressed under Miranda. Every statement that is a response to an interrogation
Okay,
is suppressed.
so let's
And-
assume that we're in that world.
Okay, well, if we're in that world, in other words, if
There's interrogation, there's a response, it's presumed compelled, and then you say, but we can find that something is not compelled. Well, how do we get there?
Well,
And what's the test?
Because the reason that you can get there is that consent, the inviting of consent in response to a Miranda violation is not responsive to the question. The question is seeking incriminating information, and I see my red light is on. Is a response seeking incriminating information. And we know from Miranda since 1966, what Miranda said expressly is volunteered statements are not, the admissibility of volunteer statements are not affected by this decision. Volunteer statements are always admissible. And that's why in your dead body, if you say, you know, you have drugs in your backpack and the person says, no, but I've got a dead body in my backyard, that's not responsive to the question, and courts regard it as volunteered, and therefore it is admissible under the volunteered exception, and that's what we have here.
Thank you, Mr. Casper. The case is submitted. Thank you, counsel, for your arguments. And now for those of you who weren't here after the first argument, we have about 15 minutes to answer questions, primarily from students. And I'd like to welcome some of the students who were not here for the earlier argument, folks from the Oregon National Guard Challenge High School. Welcome, Mary Thomas and students from Cascades Academy. Mountain View High School has students here, and Nate Neal and some teachers and students from Summit High School. So we will be happy to take your questions. We will not answer any questions about this case. This case is under advisement now, or about the case we heard earlier. And we will deliberate and come up with decisions in those cases in due course. But for now, we're happy to take whatever questions the students have. So come on up to the mic here. We have 2 microphones. And who's going to be first? Question in last time, so this looks like one right now. Yes, sir.
Hi, so unfortunately there's a fairly visible partisan split at the federal Supreme Court level. How do you guys deal with your own partisan biases when you address cases to do a constitutional law?
Well, that's a good question. Why don't we talk first about sort of our split? We only have 7 members, not 9, so we can't have a lot of 5-4 decisions. That makes it easier. But Justice Baldwin, you want to talk about a little bit about the sort of divisions when we divide, maybe in dissents versus majority opinions, and then maybe comment about our partisan divide. I'm not sure there is a partisan divide on this court in the same way.
I don't think there is. I think what we could do is a question a little bit similar to this morning. We all take an oath of office to follow the law, whether we personally agree with a particular law that's on the books or not. We're going to enforce it because it is part of our job. So our personal views, we do our utmost to set aside, like everybody else. We have our own life experiences and our own views, but I do believe we all make an effort to apply the law impartially, because that's so important to our justice system. Our justice system based on the rule of law is really based on the public having a sense that we will make decisions based on the law and not based on our personal views. Our court's a very collegial court. We pull together and work together on these difficult issues, but from time to time, and I think not only in constitutional law cases, but in some other cases as well, each of us also has a very strong sense that we've been hired by the public to exercise our judgment independently, and that it's not about our personal view, but it is about a responsibility that we all feel that we have in that regard. So I'm not sure what the percentage is. I think that maybe at least 80% of our court's opinions are unanimous opinions. U.S. Supreme Court opinions, you read in the paper about those where the court is divided, but the majority of the decisions of the U.S. Supreme Court are also unanimous. So I don't know if anyone else wants to add.
Anybody else want to comment on that? Move on to another question. Yes, sir.
This is for you, sir, Chief Justice Palmer. At what time did you realize that you wanted to be Chief Justice, and what steps did you take, and how long did it take you to get to where you are today?
I didn't start out with this goal in mind when I was in high school or college. In fact, I figured out I wanted to be a lawyer at some point in high school or college, and I didn't think then about being a judge. But after I enjoyed practicing law. I practiced in the public sector with the U.S. Justice Department and with the Oregon Department of Justice, and I was with private firms in Portland, from Oregon originally. But I also practiced on the East Coast. And after 10 or 15 years, you start to get to know some judges, and you start to think, gosh, that's something that I might be able to do, and maybe I could be pretty good at it, maybe. And other people say, maybe you should put your name in for a judgeship. And so I and all of us have stories that are different, but they have a lot of similarities too. And so I put my name in for some judicial openings, and eventually was appointed to the Supreme Court in 2001. I had been the number 2 person at the Oregon Department of Justice and sort of administering and managing that agency for a while. I'd been managing partner of my law firm, and I enjoy the administrative, enjoy may be too strong a word. I find, to the administrators and superintendents here, there's something that's rewarding about helping a worthwhile organization do its work better. And even though it means worrying about budgets and worrying about personnel issues and worrying about our technology systems and things like that. And so my colleagues selected me as chief about 2.5 years ago, and I enjoy the work. I enjoy writing opinions and thinking more about the legal issues too, and now I have less time to do that. That's the sort of short version. Thank you for the question. Yes, sir.
So my question is kind of simple, but I just wanted to ask, what do you guys write down in your little notepad?
Just a door. What do you write down on your little notepad? Well, you don't write for us. You take it all in.
No, that's not exactly right. I have to take notes. It's really a very, very good question. And I think first of all, what you may not know is that the parties have given us briefs. Some of us have them in electronic form, some of us have paper briefs that explain their sides of the case. And so we've all read those and studied them before arguments. And so that's why we have a lot of the questions we do. Most of us are thinking in at least 2 different ways about oral argument. We're learning additional information about the case, hopefully. Hopefully oral argument isn't just lawyers getting up and repeating what they've already written, because that wouldn't be helpful in the process. What we're trying to do here is deal with questions we had after reading the briefs about the differences in the parties' positions in the case and why they're different. So what the court's trying to do in many ways is synthesize these arguments, and with the help of good lawyers like we've had in both cases this morning, who are prepared to answer the questions, not just repeat what they've written, try to arrive at a better understanding of how the case is going to be resolved. Now that evolves. We're going to meet together after arguments here this morning, talk a little bit about the case, and then the chief will assign this case to somebody to write on, and we'll all think a lot more about the case as it moves forward in the process of preparing an opinion and a decision. But these notes that we're taking are all part of jogging our memory, of trying to figure out the best way to reconcile the differences, and they're little notes to remind us of what we think the key points about the case are. So we'll go back later and look at these notes and think about them when we read a draft opinion, think about them when we talk with each other about the case, and use them to remind ourselves of what we think are the important issues to decide. It's all part of that evolution of the case starting out in the trial courts and then getting all the way through a decision. It helps us remember what we think is important and why we think it's important.
Thank you, sir.
Yes, sir.
This one is for you, Mr. Casper. I was wondering what you have to do to go and get ready for a case like this, going through everything. What is the hardest thing, and how are you able to be prepared so easily and go through it so simply?
Why don't you stand up to the mic there? Yeah, Mike.
Well, it's not easy, and I don't get a lot of sleep. The hardest part about preparing for the arguments like this is just trying to be ready for who knows what's going to come. So you end up, I always try to anticipate whatever questions we have. I work with a great team of lawyers, and we have a moot court, so we have a practice argument where people pretend to be, they pick their favorite judge, and they pretend to be and we do our best to try to figure out what are they going to ask, what's going to be bothering them, and really work out the answers we want to give beforehand. Sometimes we predict correctly, sometimes we don't. But it's hard. I mean, there's always kind of a strange feeling after the argument. It's not exactly a letdown, but you do some tremendous amount of work sort of trying to guess all the things that might be asked, and then you end up sort of actually focusing on a fairly small thing. And I've never walked away from an argument thinking, I said everything I wanted to say. I always think, I forgot to say that. So it's a hard thing to get ready for, but I mean, I think it's a lot of fun. And this court in particular, they're very, it's a generous court, and I think they like to engage in conversations with the attorneys, and it doesn't feel intimidating. In the past, there have been justices that were a little more intimidating.
That's something we need to work on right now. We've got to find somebody more intimidating.
So yeah, it's just a lot of reading and outlining. Yeah.
Thank you, Michael. Yeah, I think let's take the two from this side and then one from that side, and then we'll have to quit.
Hi, so when I do ask this question, I am not referencing any case. I did watch the one that was first, but do know when I do ask this question, I'm not necessarily referencing that one or any case in particular. Where do you, as justices, draw the line between state laws and religious freedom?
Boy. I know it's not, you're not talking about a particular case, but sort of that's part of the issue in this case. So I hate to duck what is really an interesting question, but that's one of the fun things about this job is we get to talk about that among each other for a long time, and this will be one way or another some specific application or not of those general principles. So I'm sorry to not be willing to answer that, but it is a terrific question. I think it's a great thing to talk about in your social studies class or government classes or religion classes for that matter, because these are very important things in our state and federal constitutions, and they go to the way we organize ourselves as a society. One of the difficult but also rewarding things about these jobs is we're entrusted with trying to come up with answers that are consistent with our constitutional principles, but also make sense, in 2014. So thanks for the question.
Thank you.
Let's go over here, and then we'll have this last one from the other side. Yeah.
Sir, how do you, throughout the justice system, how do you change the rules? Like, do you guys normally change it by the actual Supreme Court, or do you guys, like...
I think we can work with that question. We're going to talk about how we change the rules and who changes the rules, Supreme Court cases, our cases, statutes.
So let me tell you where the rules come from in the first place. They're like probably three sources. One is common law, which was developed in England back, when Chaucer lived. And you get all these judges who decide cases, case to case, and develop a body of law that we all inherited when we became a country. Second place we get our law is from statutes, and that's what the legislature tells us. And the legislature is composed to reflect the majority of people in the state. They vote on issues, and whatever they say will guide us, and we, at least in my view, and I think all our views, our job is to follow whatever the legislature intended. If we can figure out what it was the legislature wanted us to do, we're supposed to follow that and try to figure that out. And we don't get to change that just because we think we would have done it differently than the legislature would. Third place is the Constitution, and the Constitution, well, there are two Constitutions, the Oregon Constitution and the Federal Constitution. Federal is going to be supreme, but both set out general principles that guide the way that we constitute our government and that provide protection for us in terms of adult rights. We, from time to time, interpret both statutes as to what the legislature meant and what the Constitution means, and those cases guide us in deciding what they mean as they apply to future cases. Sometimes we realize that we made a mistake, and it's a power that we don't exercise that often, but we have the authority to say, gosh, you know, if we look at this case, we just got it wrong. Usually somebody else got it wrong, but but basically that it is something that we think that wasn't well reasoned, really doesn't have support, and when you look at it really closely, doesn't stand up to analysis. In those rare instances, we can at that point choose to overrule the case. But it's a pretty big step, because most of the time, there's a body of wisdom that builds up over time, and that wisdom guides us. So, a lot of the time we're talking about, well, okay, we have the old case, but how does it apply to this new situation? Is it the same situation as a different situation? So that's pretty much how we do stuff.
Thank you. Thank you for the question. Yes, sir.
Hello. I'm not quite sure how to word this, but what do you think of laws not being taught in schools or like not being common knowledge? And I don't mean like don't murder people, don't steal stuff. I mean like the little things like you're not supposed to have too many pets, or they can actually get taken away from you, or not touching the fog line when you're driving, or having a curfew in a town that most people don't grow up being told about.
So Justice Walters, you want to talk about laws and what we think about them, and ignorance of the law not being a defense, and things like that?
I think that this is really a good and important question, and something that we are concerned about as judges is that there's just not enough time in school to learn everything that's important to being a citizen. And one thing very important to being a citizen is to know the laws. And I can't tell you how many of them there are. If we were in our courtroom in Salem, you'd see that we have the books that Justice Kistler referred to the statutes that the legislature passes. Well, their books take about this much room on the shelf. And then we've got the books where we've decided an issue about what the law means. Those take up a whole wall. And so there's no way that a school could teach you every single one of those laws. But they can teach you the general principles and teach you, have you understand that it's important as a citizen to learn the laws that will affect you. And so it's kind of it's not just the teachers need to teach, the citizens also need to learn. And you can't learn them all, but you can know where to look, and you can care about the law and the development of it. Because one really important thing that I hope you take away from this is that we aren't the law, that the citizens are also very important to making the law, and we have a role to play, but not the whole. The law isn't just ours alone, it's yours too. And if you think that the law should be changed, that's something that you can do as a citizen. You can ask your elected representatives to change that law. So we're all responsible for it, and we all have a part in learning about it.
Thank you. That's a great way to end it. So thank you, students. And I wanted to acknowledge one of the group of students that came in for the second argument, the students from Ben's mock trial teams, Ben High Schools, and we're glad that you came too. This was a terrific visit. We enjoyed being here. It took a lot of work of a lot of people to make this happen, and I wanted to again recognize Alicia Sikora for doing a lot of the arrangements here. The judges from Deschutes County, the Deschutes County Bar Association, our host, Ben Senior High School Principal Chris Reese. There are also, as I mentioned at the earlier argument, We have folks from the Deschutes County Sheriff's Office. We have the district superintendent and some assistant superintendents from Ben Lapine. We've got some folks from Redmond High School, from Central Oregon Community College. We had Ben Mayor Pro Tem Jody Barham came down, and we are very appreciative of everybody who was here. There are two other people that we didn't really thank before. Ty King for his help with setting us up in the theater area. We know this is an area that students like to use a lot, but we're glad that you were able to make that available to us. Julie Reynolds and Linda Kinney are our OJD staff people who come from Salem. They came and did advanced work for this, as did our security team, and we could not do this without them. Finally, the Ben High School culinary team made this unbelievable breakfast with quiche and beautiful cinnamon rolls and things like that. There are some leftovers, so I assume those will be parceled out to people at some point. But we are very appreciative of their efforts, and thanks so much to the Bend culinary folks. So that concludes our proceedings today. Thank you again for being so attentive.